Good morning and good afternoon to everyone. Thanks for joining us at the Labor Law Year in Review, Labor's Biggest Hits. This is the second webinar in our fall series, which will continue on December 3rd. My name is Erin Porter, and I'm a partner and the chair of the Ontario Labour, Employment and Human Rights Group here in Toronto. My practice is focused on advising and representing employers in labor, employment, and human rights matters, but I do spend most of my time dealing with labor arbitrations and a lot of time presenting before arbitrators and the Labor Board. Before we get started, I would like to provide a land acknowledgement. First Nations and Inuit have been present in Canada for thousands of years. These Indigenous peoples have a profound and ongoing attachment to this territory. At Fasken, we recognize that we have a role to play in the ongoing process of reconciliation between Indigenous and non-Indigenous communities here and elsewhere in Canada. We have embarked on the reconciliation journey by adopting a plan with the overall purpose of contributing meaningful to reconciliation. While I introduce our Cross-Canada panel, please take a few moments to look at the information on your screen. So first, I'd like to draw your attention to the survey piece. We value your feedback, particularly if it's positive, and ask that you would fill in the survey before you log out of the webinar today. We're also pleased to announce that today's session qualifies for CPD credits with the Human Resource Professionals Association. The HRPA credit code will appear on the screen at the end of the event. We will also be sending out certificates post-event as well, should you miss the code. We are continuing with our automatic Ontario and Quebec CPD certificates, and the QR code and link will be shown at the end of the session. It's now my pleasure to introduce my fellow speakers and co-presenters today. So first, Dave McDonald is a partner in our Vancouver office. Dave is a leading labor, employment, and human rights lawyer, and employers seek out his skills as strategic counsel in workplace law. He has a particular focus on labor relations and collective bargaining. He also gives advice in all areas of employment law, human rights in the workplace, and occupational health and safety. Laura Epplett is an associate from our Toronto office who has a broad labor, employment, and human rights practice. She advises both private and public sector employers in provincial and federal sector industries on various workplace matters related to labor relations, workplace investigations, employment agreements, workplace policies and procedures, drug and alcohol testing, and the list goes on. So I'm thrilled to have both David and Laura here with me today. Now, on to the presentation. We've got an agenda here that touches on the 6 different topics that we will discuss today. We'll try and go through a couple of different cases for each topic just to give you some of the highlights and things that we have found really interesting from the past year. We'll start with just cause, move on to free speech, then sexual and psychological harassment in the workplace, privacy, collective agreement interpretation, and finally talk about privilege. We're going to keep you active throughout the presentation, and so we're going to be doing some different surveys. When a poll appears, we're going to ask that you vote, and I may have gone one slide too soon, but you should see a little voting button down on the corner of your screen. So you can see over here by the chat, it will say vote. And then you click on that. And when you click on that, you'll get your different options. And the options will come up here. So does your organization use a job evaluation tool? So you can respond yes, no, or unsure. And once you respond, then the box should appear blue. And after that, we will then get the results of the polls in real time. So it'll be a good way to indicate some of the different things that are going on in the different organizations across the country. So just to practice, we have a test question for you. So here's the test question. What day is it? So you can all take a moment and see if you can find that voting box down on the right-hand side of your screen and vote to see if we can determine what day it is. And only 98% of us believe that it is November the 13th. So we're almost all the way there. We would have also accepted the first day before Taylor Swift descends upon Toronto. So that is the big news here in the city for those of you who are Swifties out there. Great. All right. So with that, I will pass things over to Dave, and he is going to talk about just cause terminations.
Thank you, Erin, and greetings everyone from the wet West Coast. And it's very exciting being Taylor Swift Eve for you in Toronto, I'm sure, and we can't wait for that to happen here in Vancouver. So we're going to talk about just cause terminations. I'm going to review 3 recent cases for you. And as Erin mentioned, we will be asking you to play arbitrator as we go through each of these cases. Of course, I think the reason all of us are in labor and employment or labor relations as a human resources professional is to have the opportunity to fire people. It's why we get out of bed. So these cases go first because they are the most interesting, and let's jump right into it. So just cause terminations. The first case we're going to talk about is a decision that was argued by our colleague Christian Paquette in the Toronto office. It's a school case, Nouvelle Ontario Catholic School District School Board versus the Teachers Union in Ontario. And this is a case from Sudbury where the local union president took a leave of absence from the workplace. And she cited a toxic work environment, which caused a disability from work. And she had been away from work for a number of months, receiving long-term disability benefits. When it came to the employer's attention that the employee was teaching courses at a local college, her job with the school district was an education assistant, so not quite the same role as a teacher at a college, but in the same field. And the employer was also aware that the employee had been working on behalf of the union throughout the course of her disability leave. So she was presenting grievances, she was filing human rights complaints on her behalf and speaking on behalf of other employees. And the employer felt that this behavior was inconsistent with the reason why she was off work and was receiving long-term disability. So the employer asked the employee about these concerns it was having, was not getting satisfactory information from the employee, and terminated her employment. The union challenged that termination, and the issue went before arbitrator O'Neill. And in April of 2024, we had a decision. So the background, I think I've summarized here. The employer's position is set out in the second bottom bullet there. The employer had learned that she was working elsewhere and tried to get information about what she was doing to make sure that that was compatible with the reason why she was away from work. And after failing to receive this information, the employer terminated her employment. And that was a for-cause termination. The union says, well, look, you can't say that this is incompatible with her limitations, employer. And there is nothing inconsistent with being disabled from working in one workplace with the other activities which she's alleged to have done. So these questions come up from employers a fair bit when you have employees off on disability leave and you become aware that they're performing activities that you think might be inconsistent with the reason why they're on a leave. So this is a tricky issue. It comes up often. It takes some time to get to the issue, but here we are. And we're going to ask you, if you were the arbitrator, what would you do in this case? So now put your arbitrator hat on, and we'll move to the polling buttons and see did the arbitrator uphold this employee's termination in this case? Let's see what you think. And right now, the results are coming in. Okay, this is like election night last week. Let's see if we're as surprised by the results here. So we have, looks like we're coming in around getting pretty even now, but it looks like the majority of people being polled, 59 to 40%, 60 to 40% roughly, are saying, yes, the employee's termination was upheld. So let's turn and see what the actual result was from this decision. And 60% of you are correct. There was a decision to uphold the termination. And the hint I gave you right at the start is our partner, Christian, argued this case. So of course the termination was upheld. But when you come into the when you get into the case, what was a relevant factor was the union failing to call a medical practitioner. The medical file was available, but the doctors didn't come and say. So the union's argument that there's nothing that in the evidence that shows that this is incompatible behavior. The arbitrator said once the employer has shown that the behavior was happening, that's enough of a question. That satisfies it. And then the burden has shifted now to the employee and the union to say this behavior was in fact compatible with my restrictions. So this was a good result for employers, and 60% of you would be used as our arbitrator in this case. So that is the first case. The second case is a bullying case. This arises from a municipal context in Niagara, and the employee was a long service employee, 21 years of service, and in fact, he was 6 years away from retirement. Interestingly, in this case, I think most of you that deal with employees in the workplace know that bullying behavior often doesn't just start out of the blue. It's usually repetitive behavior. If somebody's been a bully and they've gotten away with it, over the years, that behavior has a back pattern to it. In this particular case, the employer did not rely on progressive discipline. So the employer relied on a single investigation into a single complaint from a coworker that said how this person, my coworker, treats me has affected me. The employee testified about suicidal ideation, the bullying behavior was really chronic and repetitive and quite severe. Now, the employee at arbitration, the grievor, had previously been disciplined, but again, that they didn't rely on the earlier discipline. It all arose out of this investigation report, which the employer had prepared. And at the hearing, the grievor expressed remorse. He said he was sorry. He said he was prepared to apologize directly to affected employees, and indicated that he was prepared to take steps to improve his behavior. At the same time, though, he denied and maintained his denial of some of the more serious allegations. So when it was put to him directly at the hearing, you said this to this person, he would deny those allegations, despite having apologized for his behavior and acknowledging that in the past he had been a problematic employee. So that's the background to this case. 21-year employee, effectively a clean record, being terminated on the basis of this investigation. So let's put your arbitrator hat back on. And the question for you is, did arbitrator Knopf uphold the employee's termination? Bullying case, long service employee, not relying on the record. Okay, so we're looking like our numbers are the majority of people at about a 65% level are saying this employee is coming back to the workplace. Okay, let's call it at 70% to 30. 70% say no, this termination was not upheld, meaning the employer didn't have cause or the termination was excessive. So let's see what happened. And the termination was upheld. The employee stayed fired. And the reason for that in the decision was primarily the employee's failure to acknowledge the worst aspects of the behavior. And the arbitrator also relied on post-termination evidence that the workplace really had improved in his absence. So I agree with the majority of you. This is a somewhat surprising finding on the basis that they didn't rely on the previous discipline, and the union didn't really press this environment's just toxic. I think that's a harder argument for unions to make these days, given the heightened sensitivities around bullying and the proper focus on mental health in the workplace and removing people quickly that are chronic bullies. So another good case for employers, the Niagara QP 1287 case. The final one we're going to cover is another school board case. And this is the Dufferin Peel Catholic School District Board case. And those of you who maybe you've heard of this case, but maybe not, maybe you remember the janitors at the groundskeepers at your school being people with sort of limited work ethic. That was certainly the case in this grievance. Again, it was a relatively long service employee, 16 years of service. He had a clean discipline record. And the employer really had a look at this guy and what he did over a 2-day period. And there were 4 separate things that the employer relied on to terminate this employee over the course of 2 working days. He had taken a weed trimmer home with him. It was school board property. And the evidence was that the grievor actually on the side ran his own groundskeeping company. He actually removed a shrub from school board property and installed it at his home, a decorative shrub. And he part of his job as a groundskeeper for the school board was walking around the outside of the school, picking up trash and noticing if there are any unsafe things. But this employee was observed and was in fact videotaped playing golf for about 20 minutes on one of the days in question. And then he spent 2 hours washing his personal vehicle. So the employer terminated his employment. The union says, look, these are, many of these things are, the weed trimmer was a mistake. He just took the wrong piece of equipment home. The shrub was garbage anyhow. And golfing and washing his car, those are disciplinable, but really he shouldn't lose his job of 15 years. So the grievor had participated in the investigation. He had acknowledged his wrongdoing, but interestingly, at the arbitration, he denied wrongdoing. So he kind of changed his position between the investigation before his termination and while testifying before the arbitrator at the arbitration. So the final question for you in this section is, did the arbitrator uphold the employee's termination? So let's see what you say. This is the groundskeeper who, over the course of 2 days, took a weed trimmer home, took a shrub, played golf, and washed his car. Are you going to fire him for that? Looks like we got a pretty close split with the plurality of you. 50-50. Okay, this is as close as it gets. So, okay. For half of you, I'm going to apply for a job as a groundskeeper because the end result was this employee was fired, that he stayed fired. And the important factor for the arbitrator was the change in what the grievor said between the investigation and the arbitration. And the backtracking on the acceptance of responsibility was an important factor for this case. So we have a quote at the bottom of this. This is a somewhat unique case whereby the grievor simply apologized and acknowledged his wrongdoing, as he did for the most part during the investigative meeting. Those apologies would have counted as a strong mitigating factor. However, whatever benefit could have accrued from the initial apologies was ultimately undermined by his subsequent attempts to downplay his own responsibility and his refusal to acknowledge the misconduct. So, I think that this and actually the case before this go to the point that it's really not lawyers that win cases, it's really grievors that lose cases. And that certainly happened in this case. The grievor did himself no favors while testifying in this case, and he stayed fired. So half of you were right. It looks like we had about an even split across the board. So those are some of the most recent just cause cases that we're going to cover. And our next topic is something short of termination, and that's suspensions or free speech in the workplace. Is that right?
Thanks, David. And one of the things that I love about the case that Dave was just talking about is that the griever was actually cleaning his personal car. And when asked about it, he said it was because he got the car dirty stealing the shrub. So he unplanted and took the shrub home in his truck, and then thought that obviously his truck was now dirty from his thievery, and so he had to clean it while at work. And I love that for so many reasons, because I think it's kind of epitomizes sometimes the facts that we're dealing with, and how truth is often stranger than fiction. All right. So the next case that we wanted to talk about was a recent decision out of Alberta about free speech in the workplace. And this case is UFCW and Sobeys, and they were in a contentious wage reopener period. So they were trying to negotiate increases to wages post-pandemic. And I say post-pandemic, who knows what period that actually truly was. But in any event, post-pandemic, and after the grocery workers had lost sort of the premiums that they had been originally provided during the pandemic as being essential service workers. And so the union distributed buttons, and the first button said, "I'm still essential." And you may have seen similar messaging in your regions as well, where unions were either putting out commercials, having advertisement on public transit, and in this case, wearing buttons that said, "I'm still essential." And then the second set of buttons, there were two of them. So one said, "Greedflation hurts," and the other one said, "I can't afford to shop here." And so employees were given these buttons and were told to wear them while they were at work. And the employer took the position that the employees couldn't wear the second two buttons. So the "Greedflation hurts" and "I can't afford to shop here." They didn't make any sort of comment around the first button that said, "I'm still essential." And the union took exception to that, saying that, there's a long established practice where employees are allowed to wear union buttons, and that this is an impingement on their right to free speech. The union also at the same time produced a commercial. And so they had this 30-second commercial that was airing on both TV, so traditional media, and then also through social media channels. And it was three employees, so three of the union stewards who were part of the bargaining process, were the stars of this commercial. And they were talking again about price gouging and about, how the employer was being greedy, they couldn't afford to shop there. All of those messages were going out into the public, and really, kind of inflammatory messages against the employer. And so the employer put the three employees on a leave, an administrative leave, pending investigation, and also sent a cease and desist letter to the union. And the union then filed 2 separate grievances and a complaint with the labor board saying that the employer was both infringing again on the right to free speech, but then also that the employer was intimidating employees for their involvement or association with the union. And that treating employees in that way was contrary to the labor relations legislation in Alberta. And I think although we don't, you may not have these exact facts all the time, I think it is fairly common, particularly during contentious negotiations, that unions are now more and more frequently going to the public, and they're making sort of statements on social media. You're getting things on Instagram or Twitter or X, TikTok, whatever it is, where they're trying to now negotiate a collective agreement in the public sphere. And employers are often left wondering, what can we do about it? And I should say, too, that the union would play the commercial during the negotiation sessions with the employer. So there was no hiding the fact that they were trying to do this as a tactic to get the employer to resolve the wage reopener issue. So you've done a moderate job, I guess, of playing arbitrator so far with the cases that Dave went through. So now let's see whether or not you're able to be a vice chair at the board. So did the board uphold the union's complaint? What do you think? Was the employer permitted to put people off on a leave pending investigation? Were they permitted to tell people that they are not able to wear union buttons in the workplace? Keep in mind, not to sway the votes, but this is from Alberta, if that helps drive any of your messages. Okay, so we'll say it's at about 60-40. So most of you think that the board, that the employer wasn't able to do that. But actually, the union's complaints were summarily dismissed without a hearing. So the board took a look at the context and said that the context is really important. So perhaps the union could have been successful in making its complaint to the board if it were a new bargaining relationship. So if this was a first contract negotiation, or even more particularly, if it was a certification application, and the employer was trying to prevent people from wearing union buttons or being engaged in sort of promoting the union through external channels such as social media. But given the fact that this was a mature bargaining relationship and it wasn't seen as though either the employees or the union was vulnerable, they had an equal stake at the bargaining table, and there was no real threat to individuals for being affiliated or associated with the union. And then the board also said that it was completely reasonable for the employer to put someone off on a leave while they investigated, a situation that could be in contravention of the employer's social media policies, particularly because it was clear that this was meant to be derogatory towards the employer. And so the context here really mattered. And the board said that the employer has the right to, and the expectation that they would be able to control what goes on within the workplace. Now, that dealt with the labor board complaint. It doesn't indicate what happens with the grievances. And in fact, the board at one point says, well, that's a matter to be decided by labor arbitrators. So I suppose it's still open to determine whether or not there was a breach of the collective agreement, and the decisions on that, if they do go ahead, the decisions haven't been released. But I thought that this was an interesting case because at least I think a lot of employers feel fairly cautious about and apprehensive about what you are or not allowed to do when it comes to employees who are expressing their opinions and political opinions and things like that. But here, at least, it seems to demonstrate that you can have expectations within your workplace, and consistently apply them to ensure that employees are complying with your policies. I'm going to pass it over to Laura now, who's going to talk about some cases about sexual and psychological harassment.
Thanks, Erin. So this first case involved allegations of sexual harassment that were made by a female supervisor towards one of her male crew members. The allegations concerned inappropriate comments and unwanted attention towards the complainant. And notably, in the reasons for termination, the griever's conduct during the course of the investigation was also listed as being, as she was uncooperative, as a reason for her termination. Notably, this griever had previously worked with the Department of Public Works directly with this complainant as a colleague, and they had a close non-sexual relationship, but they both described it as more personal, friendly, even flirtatious. And it actually caused problems for the complainant in his marriage at the time. The griever then left the Department of Public Works for a period of time and then returned. And it really came about in this supervisor's return to the workplace. There began chatter amongst crew members about, look who's back. Oh, is this going to be hard for this person? And then throughout their interactions, there were some alleged contact outside of the workplace, unrelated to work, that then ultimately resulted in a complaint being brought forward by the crew member. It was investigated by the employer, and the employer ultimately concluded that all of the allegations were substantiated. And in addition, the investigator found and made comments that the griever was uncooperative during the investigation because she didn't share her notes from her notebook that she relied on in the investigation, and also that she delayed in responding to their questions. The union then challenged the termination and argued that the sexual harassment wasn't made out, or in any event, it was on the minor end, so as to not warrant termination in the circumstances, and disputed the employer's allegations regarding any misconduct on behalf of the griever during the investigation. And of course, the union sought reinstatement for the griever. Ultimately, the arbitrator conducted a comprehensive review of all the evidence and the testimonies that were presented during the hearing, which constituted the griever, the investigator, the complainant themselves, and the complainant's wife. The arbitrator found significant inconsistencies in the accounts of the alleged harassment, and noted that much of the evidence relied on was hearsay or lacked corroboration. And the incidents alleged lacked concrete evidence and were characterized by, some varying narratives. The arbitrator found that while some of the conduct may have been inappropriate, certain comments being made or contacting outside of the workplace, it did not meet the threshold of sexual harassment as defined in the respectful workplace policy. The arbitrator also criticized the employer's investigation process, highlighting that it failed to investigate the context and credibility of the claims, and that the decision to terminate the griever largely relied on testimonies of employees who were told the account of the complainant, as opposed to any direct evidence. So the coworker of the complainant testified, and a lot of their evidence was consistent with the complainants. However, there was no firsthand knowledge of the events. This was based on information heard directly from the complainant themselves. Additionally, the arbitrator found that the griever's refusal to provide her personal notes during the investigation was not uncooperative and was insufficient grounds for termination as well, noting that these were notes that the griever took in her own personal workbook and were not at all a work product that the employer was entitled to. And in any event, when there were excerpts of the personal notebook that were provided during the arbitration process, the notes actually largely corroborated the griever's testimony as opposed to the complainant's. So the employer's assertion that she was hiding evidence that would ultimately, quote unquote, convict her was unfounded. The arbitrator also noted that the griever had legitimate concerns about the investigation's fairness and perceived bias, and this was partly due to previous unresolved complaints that the griever had brought forward that were unsubstantiated by the same investigator. So ultimately, the arbitrator found that the termination was not justified and the employer had not met their burden of proof to substantiate the claims of sexual harassment or investigation misconduct. She ordered the griever's reinstatement, suggesting that lesser disciplinary measures could have addressed the issues raised without resorting to a dismissal, and emphasized the potential for building the employment relationship and the importance of adhering to fair and thorough investigative procedures in the future. The next case also dealt with sexual harassment in the workplace. It involved a crane operator that was terminated for making a sexist comment in the workplace lunchroom. And the comment was to the effect of "women are hoes." An investigation was commenced and concluded that same day regarding the alleged misconduct, which I have to say could be a record of how quickly you can get through an investigation. So several employees testified that they did hear the offensive remark made in the lunchroom and were disturbed by it. And this also included other female crane operators. The significance to note in this case and in the background was the broader concern for sexual harassment in the workplace and ensuring female employees felt welcome and safe in the workplace. So coincidentally, this comment was made in close proximity to a discussion at one of the toolbox talks, which was a morning powwow meeting discussion where they actually went over concerns regarding respect in the workplace. So considering all of that, the company swiftly looked into the allegations of sexual harassment and began their investigation, collected statements, and quickly decided that the griever's comment violated the company's zero tolerance policy on harassment. The decision was made to terminate the griever, which was also supported by the VP of Operations. And they also reiterated the company's commitment to maintaining a harassment-free environment. The griever in this case maintained that the comment was part of a private conversation they were having with a coworker, but the company concluded that the behavior was unacceptable, especially considered that it was taking place in a setting with female employees present, and they didn't want to, they wanted to send a strong precedent in the future for anyone not to commit harassment in the workplace. The union's position, they conceded that some discipline was warranted. However, they noted that the griever admitted to making the comment and argued that termination in this case was an overreaction by the employer, saying that, again, to the griever's point, it was a comment made during a private conversation intended to console a coworker who was currently having some relationship issues with an unfaithful partner. The union stressed that the context of the remark was not properly considered in the employer's investigation. And they also argued that the investigation was hastily conducted and did not provide the griever enough opportunity to provide this adequate context behind the comment. The coworker to whom the conversation took place with also testified and admitted that he found the statement offensive, but didn't recall anyone else's reactions at the time. And he, again, provides some more context behind the conversation and how it took place. So we're going to ask you again to put on your arbitrator hat and decide, did the arbitrator uphold the employee's termination? So you're a very inappropriate comment in the workplace. Do we think it was upheld by the arbitrator? Okay, we're going back and forth. Oh, we're leaning more towards no, it was not. We're almost at an 80-20 split. All right, let's see whether you have hit the nail on the head. So the arbitrator ultimately determined that while the comment was inappropriate, it did not rise to the level of harassment that was severe enough to warrant termination. So the majority of you were correct. So the facts of the case, and the griever admitted that he did utter the comment. The exact phrasing wasn't completely consistent, but it was an iteration of the comment alleged. But they said that, and the arbitrator did commend the employer in its efforts to address the workplace harassment immediately and to ensure that it met its obligations to have a workplace free of harassment. However, they did note that the investigation was inadequate and it did not capture the context or involve proper interviews with all of the witnesses. They were statements that were collected, but a proper interview was not conducted with all those involved. The context of the comment, again, was critical, and while inappropriate, wasn't sufficient to warrant termination. And as such, a 3-day suspension that could have been coupled with some education for the griever would have addressed this incident more appropriately. Alrighty, we're going to move on to the last case in this section. In this case, we're looking at psychological harassment in the workplace, and this is taking place in a daycare in Quebec. So the arbitrator was tasked with determining three issues in this grievance. So in the fall of 2022, multiple educators came forward at a daycare center with complaints of psychological harassment against the griever, who was a floating educator. So this griever was an educator at the daycare. She did not have a specific room, such as an infant room or toddler room, where she was regularly teaching. She provided backup floating support for those who were off or required breaks. The complaints primarily centered around the griever's behavior towards her colleagues. One colleague complained that there was an altercation on November 16th in 2022, which led the employer to commence its investigation. This involved aggressive behavior from the griever, who verbally assaulted her and raised her voice during a disagreement over some childcare activities and a new policy regarding wall storage. The complainant noted in their complaint that this incident left them feeling unwell and humiliated. Another educator came forward with a complaint of feeling mocked by the griever for her treatment of children. And this educator's experience was being accused behind her back by the griever and led to quite a confrontational exchange. Other educators who were not involved in the November 16th incident came forward and noted the stressful impact of the November 16th incident with the other educator and corroborated how stressful it was for the complainant. Other educators gave evidence about their negative interactions with the griever and corroborated the other educators' incidents taking place. Finally, one educator recounted a conflict over end of shift procedures where she felt undermined by the griever's behavior during a meeting that was meant to clarify protocol. So the employer investigated the psychological harassment complaints that came forward and in the interim placed the griever on a suspension during the investigation. The complainant's testimonies consistently described the griever as aggressive and domineering. And in contrast, during the investigation, the griever maintained that her actions were merely misinterpreted and her side of the alleged events differed significantly from those of the complainants who were consistently supported. And they seemed to be at odds with her colleagues' explanations of what took place, which highlighted the ongoing conflict and tension in the workplace. So at the ultimately, the employer, after getting the report, found that the griever's actions amounted to psychological harassment in the workplace, and she was ultimately terminated. Notably, the griever also filed a complaint of psychological harassment 5 days after the incident that led to the complaint against her. And so at arbitration, the arbitrator was tasked with determining whether the suspension and the eventual dismissal of the griever was justified, and then whether the griever's retaliation complaint had any merit. So at arbitration, the arbitrator found that the suspension and dismissal were justified. And the arbitrator reiterated that the law requires employers to take reasonable measures to put an end to harassment, and employers must be cautious when receiving complaints. And so when faced with serious allegations of psychological harassment, they have an obligation to investigate, and it would be difficult and place the employer in a difficult position to allow this individual to stay in the workplace while investigating the complaint. So administrative suspension with pay for purposes of an investigation is not only used to eliminate the risk to other employees, but also to justify a decision affecting an employee's employment relationship. So ultimately, if psychological harassment is substantiated, but this individual has been in the workplace the entire time, it would undermine an ultimate decision to terminate. As well, the arbitrator noted that given the size of this workplace, it wasn't one where the employer could reassign this griever to another area to do other work during the course of the investigation, where they would not have any interaction with the complainants. So on a whole, the arbitrator found that the suspension was valid. In terms of the dismissal for psychological harassment, the arbitrator concluded that the evidence demonstrated that the griever was, in fact, the perpetrator of acts and comments that do meet the definition of psychological harassments as defined in the Act Respecting Labor Standards and the Workplace Harassment Policy. And this was reached given an overall analysis of the evidence, including this November 16th incident, which triggered the investigation, as well as an assessment of the evidence provided at the hearing. The arbitrator also found that dismissal was the appropriate remedy in the circumstances after reviewing a host of mitigating and aggravating factors. Notably, the arbitrator rejected the griever's argument that they had no intention to harm or intimidate as a mitigating factor, stating that it's of little importance in determining the leniency shown when imposing a disciplinary measure in these circumstances, especially given that this is a civil case and not one that is tried on a criminal level where intent is a relevant consideration. And the union tried to argue that the griever had demonstrated restraint and was capable of showing composure at work, and therefore termination was not the appropriate remedy. They could have gone with a lesser penalty in these circumstances. The arbitrator declined and said that in their opinion, this was not true given the griever's attitude at the hearing, and explicitly stated, "I had to intervene during the deposition of a witness to warn her to better manage her nonverbal behavior during testimony." So again, to Dave's point, I think this is another case where the griever didn't do themselves any favors at the hearing with respect to their grievance. And then notably, the arbitrator also looked at some of the aggravating factors put forward by the employer in determining that termination was the appropriate remedy, which included the seriousness of the act, the effect of the griever's conduct, and how that was on that impact on the workplace, which other complainants expressed having to walk on eggshells or feeling that they had to quit, and the griever's failure to accept any wrongdoing, express regrets, or even apologize. Finally, in addressing the griever's complaint of psychological harassment, it was found that this complaint had no merit and was merely retaliatory once she learned of the complaints made against her. So with that, I will pass it on over to privacy.
Thank you, Laura. So we're going to go quickly through some recent privacy decisions. The first one is more of an update for those of you who have been following this particular decision. There is a development. So this has been in the media. This was a case where there were 5 GO Transit bus drivers who were terminated from their employment following the discovery of a WhatsApp group chat where some pretty vile things were being said by these coworkers about females in the workplace, including supervisors. The 5 employees who were terminated for breaching the respectful workplace policies, the sexual harassment policies that the employer had, all brought a grievance, and that grievance was heard in 2023 decision. And the arbitrator found that termination was an excessive response and, in fact, reinstated all of the bus drivers who were participating in this group chat to employment. The employer was not satisfied with that result and took it to court, and in a judicial review decision, the Ontario Divisional Court was asked to review the decision of the arbitrator, which put these bus drivers back to work. And the employer's pitch to the court was this decision is unreasonable. And in particular, the finding of the arbitrator, or the reliance of the arbitrator, on the fact that one of the supervisors who was being commented on in the workplace knew about the WhatsApp channel, but chose not to complain about it. So she had been shown the screenshots by a coworker who was concerned about this behavior that was happening, but she did not file a formal complaint and did not participate in the investigation. Effectively, that supervisor didn't want to engage in this. Obviously, I think you can infer that she was both offended and embarrassed and not comfortable in the proceeding. So the arbitrator in the original decision, which reinstated the employees back to employment, placed a lot of weight on the fact that the in that particular supervisor that was she was a big feature of this offensive group chat. She had chosen not to act, and that the court was concerned with in particular, and that was the feature that the employer used in its judicial review application. So we can go to the next slide. So thankfully, the court rectified this problematic arbitration decision. They overturned the arbitration decision. The divisional court found that the arbitrator's decision was unreasonable, and unreasonable in two areas. The first was the expectation of privacy. And in the second, which was more notable for the court, was that the female supervisor had not filed her own complaint. And the court properly noted that employers, when they're aware of this type of behavior, do have an obligation to investigate it, regardless of whether there's a complaint or not. So that was a positive development from the court. And the court, rather than dismissing the grievances, though, remitted it to a separate arbitrator, a new arbitrator. That happened back in April. We're not aware of whether another grievance arbitration has occurred yet, or whether the union has decided to simply move on and the parties have resolved it. So you may hear about that case again in 2025, but it may be dead. But the court decision is a positive one. So that's an update. The next case is one that we're going to ask you to put your arbitrator hat back on. This is a federal case. This involves Air Canada. I'm going to call it flying high. So this particular case involved a member of the crew cab, a flight attendant. So he's subject to the employer's safety sensitive policies of being air crew. He had reported for work and was absent from work for a few. He had reported sick for work and was absent from work for a couple of weeks. And then the Occupational Health and Safety Program cleared him to return to work. But during the period of time that he was away, the employer received 2 reports of potential drug use by this individual. And it's never a good sign when it's your roommates who are reporting you to your employer about your potential drug use. But that's what happened here. Both the reports were coming from this individual's roommates who were concerned about his behavior and concerned about potential substance use. And some of the facts that came out in the course of this investigation were, comments, supposed to be jokes, but this flight attendant was saying, well, look, if I'm ever caught using drugs, I have other work options. And he mentioned hijacking as a joke, that maybe that's what he could do for income. Anyhow, the employer was sufficiently concerned by this that they brought the employee in when he was cleared to return to work, sat him down and said, look, we're concerned about this. It's effectively a reasonable cause type of situation. We have reason to believe that you might be using substances in contravention of our policy. We'd like you to be tested. The problem was that time had elapsed, and a lot of the testing procedures, as some of you know, are more immediate. The breathalyzer, the saliva, all of those talk about immediate use. And so they asked for a hair sample because hair samples track more historic use of substances. The employee consented to provide his hair, but the union brought a motion asking for an order that the company not rely on the hair strand testing and prohibiting the company from using that information or learning what the test results were until there's been a determination on the grievance. The grievance being whether this collection of personal information was justified or not. So this matter came before arbitrator Kaplan, who is the chief arbitrator that the parties use for these type of issues. And it was so remember, it's a preliminary motion about the use of this evidence, about the use of this drug test. And the question for you as an arbitrator is, would you grant a motion from the union preventing the employer from having access to the results of the test until there's a determination that the test was conducted in a reasonable manner, the collection of the sample was not a violation of the collective agreement? So let's put on your voting tabs and see, would you grant a motion of the union preventing the employer from having access to the test results? Okay, it looks like the majority of you have flights coming up and you are concerned about flight safety. Oh, no, now it's more safe. Okay, we're 50-50. Within the margin of error. Okay, so it looks like we're evening out at 40 of you granting the motion of the union, 60% of you saying, no, let's get the test results out and let's see what the arbitrator said in this case. The union's motion was dismissed, so the majority of you are correct. Hair strand testing is unusual. It is exceptional, but in the circumstances, there was no ability for the employer to conduct the more usual types of drug and alcohol analysis. And the fact that the employee had consented to the test was actually a material fact for the arbitrator in this particular motion. The company is obviously subject to a safety sensitive environment. And in fact, the company's policy, and I probably should have said this before I asked you to vote, but the company's policy says, even if a substance, i.e. cannabis, is legal or permissible to use, you shouldn't be using it because of your role as flight crew. So they did have a policy restricting on that. And it was the particular intrusion in this case was minimal and outweighed by the safety interests of the company. So that was one where the union application was dismissed. The final comment that we'll give you on privacy has to do with another school board case where, again, this was in the news, where there were two teachers that were maintaining a private blog in the cloud about concerns with a coworker and concerns about the working environment at the school in general. The principal had heard about this blog that was happening, and then the teachers were adding these things, and the cloud was not part of the server, but they were using school board issued laptops to record their observations for this private blog. The principal was in one of the classrooms when a teacher wasn't there. The principal, knowing that this log occurred, happened to hit a button on the computer and saw that it was unlocked, and then saw the blog and started to take some photos of the blog on the camera and use that to initiate an investigation into what these teachers were doing. So there was a long back history. This made its way to the Supreme Court of Canada. And the issue in the Supreme Court of Canada had more to do with the application of the Charter of Rights and Freedoms and its prevention of unreasonable search, whether that applied in a workplace or not. So this may or may not apply to if you're a public body, but the quote from the Supreme Court that we put here for you to think about is this idea of expectation of privacy and the idea that it's all contextual. So an employer's operational realities, policies, and procedures may affect the reasonableness of an employee's expectation of privacy. So I think the message here is, if you are going to have a situation where you're looking to access potential employee information on your system, you have a pretty clear clearly worded policy that you will be doing this and that this is not a breach. Otherwise, there can be a finding of a reasonable expectation of privacy, or if you're a public employer, an application of the Charter of Rights and Freedoms to your operations and your role as management. So we'll now turn it over to our next speaker on collective agreement interpretation.
Thanks, Dave. The Metrolinx case, every time I hear about it, it gets me enraged, at least the arbitration decision, because, the arbitrator, I think at one point makes a comment about the fact that these were people acting like boys rather than men. And I'm like, well, anytime you have to justify the behavior like that, then I think that there's maybe a problem that warranted more than what he had done with a reinstatement with full back pay. But thankfully, the Superior Court was able to rectify that. So on to collective agreement interpretation. So you probably, if you have collective agreements, then you probably have a fair bit of your grievances revolve around trying to interpret the language in that collective agreement. And arbitrators will go at great pains to say every word has meaning, except when they don't. And then if they do, but what did they mean? And it almost seems to be this cycle where you go round and round. And so this case, I think, is a perfect example of that. So the Ottawa Police Services Board and the Ottawa Police Association were in a dispute about the language around public holidays or statutory holidays in the collective agreement. And the collective agreement had language that stated that in addition to the dates specifically enumerated below as statutory holidays, if there is a day that is proclaimed, it will also be considered to be a statutory holiday for the purposes of the collective agreement. So it talks about what happens if something is proclaimed. And I think what the parties were probably trying to do is capture things like what happened when you introduced, or the government introduced, something like Family Day or Truth and Reconciliation Day. And so what happens when an additional statutory holiday is proclaimed? What's the impact on the collective agreement? But it doesn't say anything about statutory holidays. It just says when a day has been proclaimed, it will be included as a statutory holiday. And so the arbitrator found that, well, the language is what the language is. And so the parties turned their minds to it and they said, they said when a day is proclaimed, and sure enough, a day was proclaimed to commemorate the passing of Queen Elizabeth. And so they said, well, the day has been proclaimed and therefore it must be a statutory holiday because that's what the language is. And then the arbitrator Waddingham, even goes so far as to say it's probably not what the parties meant. And it really isn't fair to the employer, and it's going to have some cost consequences that surely couldn't have been intended. But there's no evidence to suggest anything to the contrary, that there could have been any other interpretation or reading to the contrary. And they use the magic word proclaimed, therefore the day has to be included. And so the employer appealed the decision, and the court overturned the arbitrator's rulings and said, now, come on, you can't just look at the words and have it be such a narrow interpretation. You have to look at the context and you have to look at the broader meaning. And what you're trying to do when you're doing a contractual interpretation is to try and put yourself in the minds of the people who were negotiating the contract to try and determine what did they mean. And the court said, although the arbitrator had said, well, there's no evidence to suggest what the parties meant, the court said, well, sure there is, because in the agreed statement of fact, they talked about the fact that there had been all of these other days that had been proclaimed over the last couple of years, and the union never argued that any of those should be included into the collective agreement. So it's clear from the actions of the parties over the last, 4 or 5 years what they intended when they put this language in there. And so the court overturned the decision, and as I said, really sort of looked to try and determine what is the intent, or what did the parties intend to do when they entered into the collective agreement. So I think that's, you may not have a case that's obviously dealing with exactly that language or exactly that issue, but I think that the overall principle of trying to establish intent is an important one. And you should think about that when trying to pull together whatever the evidence is going to be when you're arguing that case. So do you have evidence, whether it's bargaining notes, past practice, things like that, that will help with that contractual interpretation? The second case is a Teamsters and Purolator case, and this has to do with amendments to the Canada Labour Code. So Purolator, there were 2 different collective agreements that were being looked at in this decision. But essentially what the language allowed for was 5 paid days, personal paid days of leave each year. And under the collective agreement, employees could use those days for any reason. So they could use it if they were sick, or they could use it if they wanted to go golfing. There were no limits on what they could do. The only thing they couldn't do was add it to vacation. So they couldn't use it as a way to extend a leave where they were taking vacation time. And if they didn't use them within the year, then they would be paid out anything that was left at the end of the year. And then the Canada Labour Code previously had similar language around 5 personal days, but it was amended to then say that you could have 5 personal days, the three of which would be paid, and 10 days for a medical leave. And the 10 days, they accrued over time, but in essence, you would get up to 10 paid days of medical leave. And so the dispute between the employer and the union was whether or not this meant that employees got a total of 13 paid days, which is what the employer said. So the employer said, okay, they get the 3 paid personal days under the code plus the new 10 paid medical days. Or the union's position was that it was 15 paid days. So they got the 5 paid personal days, and because that was what the collective agreement entitled, and that the 10 new medical leave days were net new. So the employer was trying to say, well, because you can use the personal days under the collective agreement for a medical leave, then you can't double dip. You can't double count that. So we should only have to do 3 plus 10, which is the code requirements. And the union said, no. These are 2 separate entitlements, and they don't have to use their personal days for medical leave. So it's 5 plus 10. And the arbitrator looked at that and ultimately determined that the union was right in terms of the number of days. And when they were looking at that, they said, well, it's true. Like what the union is saying, that these are 2 different types of leaves for 2 different types of purposes. So the medical leave, the 10 days of medical leave, is specifically for the people being off because they're sick, or they have to go to the doctor, they have some sort of procedure. So that is very specific for that entitlement. And that doesn't overlap with the contractual entitlement that they had previously of 5 paid days that could be used for anything, including a medical leave. So you couldn't force employees to use their 5 personal days for medical leaves. So ultimately, it meant that employees were getting additional compensation because of the increase to the paid medical leave provisions under the code. Now, the arbitrator did find in favor of the employer in terms of the eligibility requirements and the fact that if it hadn't been accrued, then they wouldn't get it automatically, that it had to be accrued in accordance with the provisions of the Canada Labor Code. So it wasn't a complete loss for the employer, but ultimately on the main issue of the total number of days, the arbitrator ruled in favor of the union. And then our last section will be on privilege. We will try to save a few minutes. So some of you have sent in questions beforehand. And if you do want to type in questions, then please feel free to do that as well. And we will try and answer some questions at the end. So over to you, Laura.
Thank you. So we're going to touch on just one decision in this section, which is an interim decision that touches on some principles of privilege. So the grievance that this arose in the context of involved a griever who resigned from their position and then later, about a year later, brought a grievance forward alleging that the resignation was invalid due to their mental disability at the time. And the TTC, the employer, brought a delay argument forward with respect to the 1 year between the resignation and the grievance. And during the grievance procedure, sought production of various documents from the union, including communications between the union and the griever regarding the griever's resignation. In response to their production request, the union had provided the employer with written particulars regarding the griever's activities between the time of the resignation, which was about June 2021, until July 2022, when they filed the grievance. And these documents made reference to the griever selling their property, traveling, and also a brief stint of employment at another company. So in the large production request, the TTC sought production of various things: the employment record with this other employer during this period of time, financial records regarding any sale of their property, travel, etc. But of note to this decision was that the TTC also sought copies of any and all communications between the griever and their union relating to the end of the employment relationship with TTC and the filing of the grievance, to understand when the griever first communicated his intent to file this grievance. The union also argued at this interim motion that the communications between the griever and the union were privileged in accordance with the 4-step test from Wigmore. Now, the arbitrator rejected the union's claim of privilege and ordered production of the communications. However, there were certain caveats that the arbitrator put in place. So let's go through the analysis. The arbitrator, at first brush, did agree with the union's starting point that the majority of communications, of course, between a union and a griever that involve the griever seeking advice regarding his or her rights under the collective agreement, to be privileged under the Wigmore criteria. And the rationale was accepted that the confidentiality of union griever communications is essentially the same as those underlying solicitor-client privilege. However, the arbitrator noted that there are circumstances in which confidential communications between a union and an employee may need to be disclosed in order to prevent an unjust verdict. So in implying the 4th criteria of the Wigmore test, and to refresh your memory, that step is the injury that would ensure if the relationship by the disclosure of the communication must be greater than the benefit thereby gained for the correct disposal of the litigation. So under this step, the arbitrator noted that an adjudicator is required to balance the harm that would be done against the benefit gained by disclosure of the confidential communications to see which ought to be provided more weight in a given case. So applying this analysis to the employer's requests, the arbitrator denied the TTC's requests for documents relating to communications between the union and the griever regarding the end of the employment relationship, so the resignation, because those communications go to the heart of the union's duty to represent the griever and the griever's ability to obtain advice and representation from the union pertaining to his employment. So there had to be a very compelling reason to justify the disclosure, which didn't exist in this hand. And the employer merely suspects that the griever may have confided things in the union representatives about why he resigned, which may contradict his evidence at the arbitration proceeding. According to the arbitrator, this was an insufficient basis to find that the confidential communications would otherwise provide an unjust verdict. On the other hand, the employer's requests for communications between the union and griever related to the filing of the grievance, which again doesn't go as much to the merit of the grievance, but more to the delay argument, they were granted. And the reason being that they had to determine whether or not the delay was attributable to the griever or the union. And so we have this quote from the arbitrator regarding the privilege, stating that the griever cannot seek to rely on the timing of their communications to explain why the grievance was not filed until a year later, while withholding the documents that would confirm or refute their assertions. So in that piece of the production request, the fourth criteria of the Wigmore test weighted more towards producing the documents because it would otherwise potentially lead to an unjust verdict. However, it's also important to note that there was limited scope to the ruling. So the union was required to produce only documents that related to when the griever communicated with the union about challenging their resignation. And given that, again, as previously noted, confidentiality generally attaches to the griever union communication, any context concerning the basis for the approach, the union's assessment of it, or anything related to the merits of the possible grievance were ordered to be redacted. So again, there was a very narrow exception for why privileged communication should be producible in this context. And that was in relation to the timing or the delay for filing the grievance. So with that, I'll give it over to Erin, and we're going to get to some of your questions.
Great. Thanks, Laura. Thank you again to those who have submitted questions. If you do want to submit a question, I believe you can put it into I don't know if there's a question box or a chat function on what you're viewing, but you should, it's a chat box. So you can type your question in there and then we will see it. One of the questions that has come in is a question about what the impact is on return to work policies and family status accommodation. And I know that this has been a challenge for a lot of employers and certainly something that we're seeing a fair bit of. And one of the things I've got a case here that I can give you the citation for if you're interested, but it's Constantino and Aquapharma Canada, 2024 HRTO 860. And in this case, there was an individual who was a sales rep, and during COVID, he was in a virtual role, and the company wanted to move him back into an in-person role. Now, the case talks about there's some dispute about whether it was a virtual role or an in-person role. In any event, the company said, we want you to start coming into the office. And the employee had told the company that he had obligations to take care of his sick mother. And his mother had been diagnosed with cancer and was going through some treatments for that. And he was really the only person who was there to provide support. So, of course, we know that family status, the tribunals, depending on which jurisdiction you're in, but in Ontario, for example, it's defined as being in a parent-child relationship. And so that means both caring for your young children as well as caring for aging parents. And so he would meet under the definition of family status. And the employer, so he said, I can't come back into the office. And then he started to have some performance concerns. The employer puts him on a performance improvement plan and ultimately terminates his employment. He files the human rights application and says they didn't actually accommodate me because of my family status needs, and you need to look at this. And so the tribunal looked at the facts and said the employer didn't actually go through the proper process. Like, the employer was stuck on, we've told you to come back into the office, we need to see you here, and if you're not here, then you're not performing properly. And so they skipped over the whole procedural sort of aspect of saying, does he have a legitimate need? Are the performance concerns truly because of that need and because he needs to spend more time at home and can't come into the office? And they didn't get into that weighing of need at all. So the tribunal found that there was a procedural breach and also found that there was a substantive breach, and that his termination, at least in part, was due to the fact that he could not be in the office because of these family status obligations. And so ultimately he was awarded $25,000 in mental anguish damages, and then was also awarded money for lost income as well. So, this is kind of a lesson, a case that sits out there as a lesson to employers to make sure that you're going through, rather than just blindly saying, we need people back in the office and we have a right. Certainly employers have a right to determine whether or not work needs to be done in the office. But to take the time to go through and make sure that you're actually examining the proper questions. All right. I'm not seeing other questions come in. Dave and Laura, I don't know if you had any final words that you wanted to jump in on. Seeing none, I will thank you all for being with us today. We really appreciate your time. Please take a moment to complete the survey. We do really appreciate getting feedback and knowing how we can improve our programs for you. There are also the QR codes here that will allow you to scan to get your CPT credits, both for the Human Resources Professional Association as well as for various law societies. And if you're having trouble with that, then please reach out and we'll make sure that you get your certificate so you can get credit for this course. And then finally, we invite you to participate in our ongoing presentation series. We do have one on November 19th. It's a federal sector update. So for those of you joining us from the federal sector, please be sure to sign up for that, as I'm sure it will be fantastic. Thanks very much, everyone, and have a great day.